Hello and welcome to the criminal law section of the People's Law School. Today we're going to talk about some large issues that impact on the criminal justice system. And we have representatives with us today that represent some of the larger components of the justice system. I'm Carolyn Keeley, and I am a public defender. I represent poor people who are charged with crimes. I've been doing this about 18 years now in the criminal law business. I've done it 8 years as a private attorney and a couple of years as a felony prosecutor. Across from me we have Judge Jeff Hines, who is a circuit court judge for Division I for the circuit that entails McCracken County. And also we have Tim Kaltenbach, who is an elected official, the Commonwealth Attorney for the area that covers McCracken County, and he prosecutes and is responsible for prosecuting all the felonies in McCracken County. One of the things that we wanted to talk about first, because it's been in the news a lot lately, is money and how it impacts on the system. We've heard about budget problems and cuts to the public defender's office, to the prosecutor's office, and to the judicial system as a whole. So let's start our discussion by talking about whether or not these cuts and whether or not money in general impacts what we do in the justice system. And Tim, does it have any impact on your office whether or not you have a full budget or not?
It absolutely does. It's the state system historically has been, based on my experience, underfunded. That is that we have too many cases, too few prosecutors, too few public advocates, and the result of that is that you end up compromising the quality of justice that you have. My experience has been that over the last 10 or 15 years that the number of cases that we have prosecuted here in McCracken County have doubled. And while the number of cases have doubled, we have only increased our prosecutors by about a prosecutor and a half, and our secretarial staff by one. And the result of that is that we have less time to devote to each case, less time to get our cases ready for trial, less time to study the legal issues that are involved in each of the cases. And the result of that is that the quality of justice that we're able to give goes down. It's just if you're spending less time on a particular case, then that's what happens. And so what we've had is we've had a doubling, more than doubling of our caseload, but nothing like that as far as the resources we have to prosecute those cases.
Well, Judge Hines, I've been in this community almost 20 years in the system, and throughout that time, as Tim says, the number of felonies prosecuted has really doubled in that period of time, and yet we still just have 2 judges to do the criminal cases in circuit court. Can you tell the difference in those numbers? Does it impact you?
Well, of course, the other judge being Judge Clymer at the present time, and it does, it affects the system in ways that are more subtle. I mean, you all, primarily both of you, deal with, Tim, obviously all criminal, and you mostly all criminal now. When you were in private practice, you saw a little bit of the civil world, but part of the problem is when you impact the system with that many new felonies. The other side of my world is I 6 months of the year have to listen to car crash cases and personal injury cases and every other civil matter other than family court matters, which the family court hears. And so it's time constraining. I mean, what we find ourselves doing, I think, in both divisions is setting criminal cases during the civil trial months, hoping that the civil trials will settle so that we can give these people their day in court. And it is a distraction. I don't know, of course there are budget cuts in the administrative office at courts that that runs all the court system. I mean, the judges, the circuit court clerks, everybody involved in the court system other than other elected officials is pretty much distributed from the administrative office of the courts, and their budget has been cut. And they're talking about terminations at the state level first and then working their way down. For example, right now we have the ability to have a law clerk. Doesn't pay very much, and usually what we get is someone fresh out of law school that's waiting to find out the results from their bar exam, and they'll be there a very short period of time and move on. And I think there's a possibility that those are the type of cuts that will be made, and where that is troublesome to us as judges, what it makes us do in some cases is just make the lawyers work that much harder, because we don't have time to do the orders, the findings of fact and conclusions of law that we need to make in civil cases. So we just have to put that onus on the private attorneys, which doesn't really make them that happy, but they're getting paid, so they will do it. But that's just one of the angles that I see, is that we're forced to make more of our time in the criminal system, and that does hurt the people that practice civil law.
Well, I know, and for our office, Tim, your office handles only felony cases. And do you know what number indictment we're on this year?
I don't know. It's about probably about 350.
And your estimate for the total for the year will be what?
Last year we hit exactly 700, and of those indictments, it's a little misleading. There's probably 1,000 people got indicted, because many of those indictments have multiple defendants.
And I would say at least 85% of those defendants are represented by the public defender's office. Would that
At least, in my belief is the number that are represented by the public advocate's office is actually increasing.
And I think that is true. The other issue is our office handles not only the felony cases that your office prosecutes, but we also handle all the district court cases in McCracken County, all the river counties, which is 4 additional counties, and Livingston County. So that's, and we're down right now we're down 2 lawyers, and my understanding is those lawyers will not be replaced anytime soon because of the budget issues. So that certainly has an impact on your office, but it has an even greater, I think, impact on the defendants who are looking to have good representation from their lawyers, and the fact that our office must take all comers. Anybody that's indicted that can't afford a private lawyer comes to our office, which brings us to my next request. Can't you stop doing this? Can you just stop indicting some of these people, so it'll help us out a little bit?
Well, we require a police investigation, and so we do have the advantage that you don't. That is, we begin our cases with an investigation by either the Paducah Police Department or the McCracken County Sheriff's Department or the state police, and so they bring us the cases. They believe that they've got probable cause to make an arrest, and that's how we begin our cases. You all don't have the advantage of having a professional police investigation before you all begin your representation, and so you are to some degree more affected by the budget cuts than we are. And the answer is no, we can't stop. We prosecute those cases that are investigated and that the police bring to us.
Do you find that the knowledge that there are money problems in the system, do either of you find that it impacts on how you do your jobs?
Well, it does mine. I mean, most recently, the governor and the legislature have been complaining about prison overcrowding, and there's too many people in jail, and one of the things that does affect, frankly, I mean, is when we look at these people that come before us for sentencing, it's more likely than not that someone who has not got a significant criminal past is going to be placed on probation or conditional discharge and sent back into the community, where they may not have served very much jail time, and I don't know, you know, it's per case. Some people learn their lesson after one night in jail and they never come back. Some people learn their lesson never. And so we don't know when we put these people on probation that we otherwise could do, you know, something with. I mean, one of the biggest problems, and I think your clients suffer as much as the private clients from private attorneys in the criminal justice system right now, is one of the biggest problems we've got is lack of treatment for drug treatment. I mean, that's, I think Tim and I can agree that 90% or greater of the crimes committed in this county are driven by some type of addiction, whether it's alcohol, whether it's OxyContin, whether it's cocaine, whether it's heroin, whatever. I mean, they're stealing to get money to do that. They're selling it to get money to keep their habit supplied, or they're, you know, there's any number of reasons why, but it seems to be focused back to that. And I mean, they're complaining at the state level about the cost of incarceration, and I understand it, and I can empathize with the cost of that. But for what they spend per inmate, we've had controversy recently about a local hotel. They could build a hotel, and they could put professional drug counselors in those hotels, and about 50% of the people I've got, in particular the female population, which has just tripled in the last 5 years or so, 7 years maybe. I mean, it's just unbelievable. And if they took those people and placed them in a reasonable drug treatment facility, you wouldn't have to worry about them. They could put a check in like at the Holiday Inn and give them a card for their room, and it would save millions of dollars. And these are nonviolent offenders that aren't going to be violent offenders that need drug treatment. They don't get it in prison, frankly. I mean, there's a program, but they don't get it, and they get back out, and they're back in the same treadmill, and here they come again. I mean, for the population of McCracken County, I would say it's 10% of the people in the whole county that ever commit crimes that get prosecuted for, but they get it over and over and over. I mean, I see the same faces on a very regular basis. I mean, I'm on first name basis with a lot of these people, and if they could just get in a realistic and viable treatment program for their drug addictions, I wouldn't see them again. But I mean, that's where this Commonwealth is missing the mark, is we don't have available to this population the necessary drug treatment to stop or at least curb crime. And when we keep, you know, the idea, let's just probate them, and then they test, and they test, and they test dirty, and then you put them in jail. And the idea now is that the legislature's passed legislation so that some super commission can just start kicking people out of prison. That doesn't work because they don't know the people. I'll be honest, I will know that defendant better than any commission they can put together because that person's been in my court. Generally, I've lived in the community with them, know somebody from the family, have seen them in court before. I've been on the bench now, this will be the end of this year, 19 years, and I've prosecuted for 8.5 before that. So I know these people, and I know that if they could get the help they need, they probably wouldn't cause the problems that they do. But they're not getting it, and so they go into jail, and then they get out, and they get on shock probation or probation, and they violate it, and then we send them back to prison, and now we got these people that aren't going to know who they are, and they're going to turn them loose. Recently, there was a letter to the editor in the Paducah Sun from a woman I know, and she vividly pointed out, here's a fellow that got paroled out on a Class D felony, a minor felony offense, had a record as long as my arm, and they let him out early, and she was raped by this defendant. So you can't judge, it's like you can't judge a book by its cover. You can't determine what crime a Class D felon may commit next. If they get out and they're on drugs, they're going to do things, and sometimes it escalates into very serious crimes. And so she is one of the many advocates for, you know, lock them up and throw away the key. I don't buy into that philosophy except for some certain crimes. And some certain crimes, you know, just quite honestly, there are some people that do not do well in free society.
No, that's true. Well, we're talking about drug addiction, and one of the things that we do in this county is we have a deferred prosecution for drug court. Tim, you want to tell us a little bit about what drug court does?
It's a 18-month program, a long-term program that it was instituted about 3 years ago, operated initially by Judge Clymer and a drug court team, now by Judge Hollowell and a drug court team. And basically what happens is that if someone is arrested for a drug offense or for a theft offense, some other nonviolent offense that involves drugs, they're assessed to determine whether or not their underlying problem is drug addiction, and whether or not they can benefit from the 18-month program. What we have found out is that treatment does not work unless treatment is long-term. 18-month is about the minimum treatment. And unfortunately, so many of the people that become addicted to drugs don't have the finances or the means to treat their addiction. So many of them can't afford a lawyer, and they certainly can't afford the expensive and lengthy treatment necessary to become drug-free. So the program requires, rather than monthly drug screening, it requires daily drug screening, almost at least. It requires that you get a job. It requires that you pay restitution if you've stolen money. It requires that you meet with the counselor, and that if therapy is necessary at the beginning of the program, that you meet with the therapist. Drug traffickers are excluded from the program. People with severe mental disorders that the drug program that the drug court can't successfully treat are excluded from the program, and violent offenders are excluded from the program. But it is intensive supervision and intensive treatment of the drug addict. And if at the end of the program, the 18 months to 2 years, some people are in there for 2 years, you have successfully completed the program, and not everyone does, but if you've successfully completed the program, then your reward is that your felony offense is dismissed. And so you're basically under the thumb of the judge and the drug court team, which meets weekly and reviews all the cases. And if you mess up, you get the maximum sentence that the law allows for the crimes that you've committed. So going into the program, you have to plead guilty to the maximum offense, but your sentencing is deferred. At the end of the program, if you have been successful in doing what's been asked of you, and quite a lot's been asked, you've got a job, you're testing clean, and you're doing what you're supposed to do to become a productive citizen, then your reward is that your felony is dismissed. And to be honest with you, we've had a program with a very good drug court supervisor, as well as 2 judges that have really done a good job. And as the prosecutor in this county, I'm convinced that the public safety of the community is greater for those that go through that program than those that even go to prison and are released a short time later, which is frankly what's happening now.
Well, and speaking of going to prison and being released later, with the crowding in the prison system as it is, more and more state prisoners are being housed in local jails. I checked the website this morning, and we're rated for 325 for the McCracken Regional Jail. This morning it was showing 405 in there. I know when I go over on weekends, sometime if I get there too early on Saturday morning, I can't get in because there are mats laying all over the interview rooms with people sleeping during weekend time. And the fact is, our jail is so overcrowded that they tell me they're wall to wall sleeping and have to walk over each other on these weekends especially. And I'm wondering if there's anything that of course, the jail simply takes the people that they're sent. I'm wondering if there are alternate solutions or alternative sentencings for some of these people so that our jail isn't so overcrowded that it causes problems for community with threats of lawsuits, having to do medical care, that sort of thing. Are there alternative sentencings that can be used instead of throwing these people in jail?
Well, we do have a home incarceration program. Unfortunately, it costs money. And a lot of people that get convicted of crimes don't have money.
They have to pay for it themselves.
And they have to pay for it out of their pocket.
It is kind of pricey.
And they can't afford it, frankly. The weekend situation is created primarily, I think, certainly not from the circuit court, because we don't have people serving weekends. I think primarily it's mandatory jail time for driving under the influence convictions are the people that pile in there on the weekends. That's been my experience in the past,
yes.
and you know, frankly, you're trying to do those people a service in that they want to keep their jobs and work during the week. And these are productive people that made a mistake and got caught. And you know, there are minimums and maximums on DUI sentences, and that's why they have to go to jail. I had the benefit of living in this county and working in this county when this new jail was built. I remember the old jail because when I was a juvenile officer back when the dinosaurs roamed, I used to have to take children into that old jail, and it wasn't a pleasant place to be. And it didn't really teach them any lessons because it was the same, you know, 25, 30 boys every week we'd have to go chasing around. But at any rate, I remember the county commission, some of the commissioners just moaning and groaning, saying, oh, that's just too big, it's just too big, it's just too big. Experience will tell you one thing. You can't build a jail big enough because there's always going to be somebody getting in trouble that needs to go to jail, and there are a lot of people that get in trouble that don't need to go to jail. I think a lot of citizens would say, well, you know, if you do this, then the judge ought to put you in jail and just throw away the key. I've had controversial cases where you know, someone prominent or someone in a position of authority that has made mistakes in their life come to jail for a while and then they get shock probated. Well, a lot of people don't like that. Well, that's what shock probation is for. It's for people who don't have any criminal record, who make a mistake, and who go to jail. And, you know, Tim and I agree on this one thing. I mean, this is going to sound strange to a lot of folks, but we think that part of police training should be that you have a simulated jail and that those people that want to be police officers go and spend about a weekend in that place.
No, I would like all citizens to at least take a tour of the jail.
Well, I wish they could, but it's not, you know, the safety factor's there. But
yeah.
I mean, the purpose in that being this, the man and woman out there with the badge and the gun and the authority to arrest people, they're the ultimate authority at the point of impact. And so, you know, if you have some rogue police officer, and I don't think do in McCracken County right now, I don't think we do, but they're out there somewhere, and just decide they don't like the suit you're wearing today, so they're going to arrest you for not displaying your decal on your license plate that says it's valid till '09, and take you to jail, even if it's for an hour. I mean, just going through the booking process in that jail is unsettling to most folks, the first time at least. And so I kind of think our theory is that rather than jump the gun and make a bad arrest and put somebody in jail just because you can, and it usually, you know, it can be on a weekend, and you know, they don't have access to get out to get pretrial till the next day and that kind of thing. But you know, jail is not a pleasant place to be.
No.
There are folks that would disagree with me that love institutional living. I mean, there are some defendants that we've had in the past, and I think that they would rather be in a, you know, minimum security institution than out on the streets because they don't have to work. They get 3 meals a day. It's you know, it's a static life. They watch cable TV, and you know, outside in the outside world, they don't have anything anyway. And so this way, I mean, there's, you know, kind of a camaraderie, I think. I mean, they're just some people that are vented that way. You know, fortunately, there's not a lot of them, but I mean, the idea of overcrowded jails is going to keep on and keep on and keep on because, you know, you just can't let everybody go. I mean, that's a problem. I mean, where do we cut it off? I mean, everybody that commits a D and a C felony, the first time they just get automatic probation and they don't go do any time, and then you got a victim out here who's upset because they didn't have to get any punishment for their crime against them. And you know, one of the other big issues, I mean, the governor pointed out, the president of the Senate pointed out, they're harping about these people convicted of flagrant non-support. Oh, we got 400 state inmates that are convicted of flagrant non-support. Well, out of however many million people there are in the state, 400 people is not a lot. But I don't know about every other jurisdiction, but let me tell you about McCracken County's jurisdiction. The people that Judge Clymer and I send to prison for flagrant non-support have never, ever made any attempt to pay child support, or very, very minimal. And you know, I've had people that had a $32 a week obligation for 2 children, and they're $16,000 behind. I mean, some point you just got to punish. I mean, the idea, make them get a job, and that's a beautiful idea. The problem is, I've had men that have and women that have had jobs and have worked and have made significant incomes and still never provided for that child out there. They provided for the ones they're living with, but not the one out there. And so, you know, there are certain little segments that they're picking on that they got to understand that at some point, if it's a crime, I mean, the legislature made it a crime. I didn't. They made it a crime not to support your children. I think it is a crime if you don't support your children, myself, but that's personal opinion. And the KRS says it's a violation of the law, and if you do it for such a period of time, then it's a felony. And they don't usually get along. They don't get 5 years. I mean, they get 2 years or 3 years or 18 months, but those men and women are never going to go out and get a job and work and pay their child support. They're not going to do it.
Well, I was looking at some statistics, and they were a couple of years old, because that's the way statistics work. But and it appears that the average cost to incarcerate an individual, the average overall for all levels of incarceration, was somewhat over $50 a person per day. The average cost of probation is like $2 and something a day. And I know that there is such a thing as intensive probation, which costs a little bit more than $2 and something a day, but not nearly what it costs to incarcerated. We don't seem to have intensive probation in this jurisdiction, and I'm not sure we have it in the state at all. Are either of you all familiar with the concept of intensive probation and whether or not that might be a solution to keeping better track of people, kind of another step up toward incarceration?
Well, I've not seen intensive probation other than through the drug court process, which is really what that is.
What does that cost?
I'm not sure. We've got two caseworkers, and they're supervising about 50 or 60 people is what they're supervising, and we pay for their salaries, and otherwise everyone gives their time in the system. And also, obviously, they're the drug tests, which are done quite often. If you're in drug court, you're going to be tested whenever they tell you you're going to be tested, and you're going to be tested when you least expect to be tested. But those are really the cost, and it certainly is a less expensive option than incarceration. The problem is that it has a chance of, if you put the wrong person in drug court, you put someone who is a drug trafficker in drug court, and they start trafficking with the people who are addicted and that are in the system. No, not so far, but it's certainly one of our great fears. And that is one of the reasons why we don't let traffickers into the drug court, is because you have a bunch of people with substance abuse problems. And certainly if you have someone who gets into the drug court with not good intentions, and in fact begins trafficking, then you have a chance to do tremendous harm. And so the question with your drug traffickers is, what are you going to do with them? And the idea of leaving those people out onto the street without, in the same manner as when they were arrested, is not acceptable. And so those are the people that are going to prison, generally speaking. And right now, we don't have another solution or a better means to protect the public from those people. So, unfortunately, there are certain people, as Judge Hines has said, that simply have to go to jail because we don't have intensive supervision, as in the drug court system, is not going to be a solution for those people who choose to make a living by trafficking narcotics.
Well, and I have wondered over the years, back when I was in law school, I clerked for the Kentucky Crime Commission and did a lot of research on sentencing and sentencing alternatives. And one of the things that popped out at me was the fact that intensive probation was like, as opposed to 2-something a day, it was 5-something a day. It required like daily visits to probationers, and it truly was an intensive situation, including drug testing and that sort of thing. And it always seemed bizarre to me that rather than hiring more prison guards and building more prisons, and the state paying local facilities, at $50 a day or $30 a day, why we weren't willing to pay $5 a day to have an intensive probation system. And I don't know that anybody ever even discusses that possibility. Have you been, as long as you've been around, and I'm not suggesting that you've been around longer than the rest of us, but have you ever seen a time when that was on the table, this intensive probation?
Not specifically, but on a case-by-case basis, I'd have to say that it depends on the actual probation officer, and they take sometimes an officer will take a greater interest in a particular convict than another, and either because they want to catch him and get him in jail, or because they really want to help him and keep him on the straight and narrow. There's not any authority that I have to tell them you've got to do it this way and this way and this way. That's controlled by probation and parole. And of course, their budget is also in jeopardy this year and the next.
Well,
and
you don't have any authority. Once you commit, if this is my understanding, once you commit a defendant to the Department of Corrections, what authority do you have over that person and what happens to him?
Is it 10 or 30 days? I can't remember.
I've tried to look it up and I can't find the answer.
I think past sentencing, after 10 days past sentencing, they're beyond my jurisdiction, except for the purposes of granting or not granting shock probation, because I just lose my authority. They become a person controlled by the Department of Corrections.
They belong basically to the Department of Corrections,
exactly,
which is the executive branch.
And they can do with those people what they want. I mean, they generally, a person convicted of a felony, a man convicted of a felony, is going to be transported from our jail, if they're going to go to prison, not be in the Class D program, go straight to LaGrange for processing, and at LaGrange is where they determine where, which institution that you're going to go to, whether it's Little Sandy or Fredonia,
which I think they call that
KSP.
controlled intake.
Right, and then of course the only women's facility we have is Pee Wee Valley, and unfortunately, I mean, the gender gap is closing. I mean, we're having a whole lot more female felons than we've had Certainly a lot more back than in 1980 when I was a felony prosecutor. I mean, the rare occasion that we had a female defendant was usually because she was attached to some man who gets her into the trouble. And now with this, I mean, the drugs are, I mean, frankly, epidemic proportion everywhere, and we're no exception. You know, if people want to believe it doesn't exist, I hope they get to be on the grand jury, because every grand jury that I return indictments for, I say, don't you think, folks, maybe we got a little drug problem in McCracken County? And they all just shake their head, because the average citizen doesn't see it. I mean, they're not at the courthouse maybe once a year to pay taxes, to get their driver's license renewed, to renew their car tag. They don't come up into the criminal justice system and see what goes on there. There was a time when people used to get interested and would show up and watch trials and watch court. Right now we got, I think, one man that comes to watch anything. And even when I was in district court judge, I had 3 or 4 guys that came all the time. Of course, sadly, they're all deceased. They were my friends. But people don't, I don't think the interest is there. They just read about it in the paper. And a lot of people, I hear of my friends, among my immediate friends, reading about the McCracken District Court news. Well, you know, what they see in there is about 1/50th of what goes on every day in district court. I mean, that they just print kind of what they kind of cherry pick and put in there.
I've noticed that.
Yeah, I mean, well, there's no way they could print the whole docket, because you've been in district court.
Can't get out again.
I've been in district court, and traffic court had 200 pages when I was a district court judge, and there's no way they're going to print all that. So, you know, unfortunately, we've got serious drug problems that result in crimes being committed. Whether it's domestic violence, whether it's breaking into somebody's house, whether it's stealing your car stereo, it's just so driven by drugs that treatment for, you know, at the young age, when you get these 19-year-old kids in there, and I know they want to be grown up, but they're kids, and they're 19 or 20, and they make a mistake and they get caught. You know, if you can get them treatment, and a lot of families, with the means to get treatment for their children, and have tried. Mr. Kaltenbach is right. 30-day programs don't work. 60-day programs don't work. Most of the time, 90-day programs don't work. And believe me, I've seen these people that have done it. I mean, they've been to Betty Ford, they've been to California, to other treatment centers, 30 days, 60 days, 90 days. It doesn't work. I mean, look at these young movie star, music people going off to the Betty, they call it, and doing these 30 days. It doesn't work. I mean, you have to be committed to getting better and getting rid of the addiction, and you have to spend 1.5 years to 2 years, and then you get to, guess what? You get to spend the rest of your life every day fighting that addiction. And that's what these people that are successful do. And I mean, one of the scary things to me about the drug court has always been that big hammer. I mean, I've got a young man pled guilty in my court the other day, 20 years. 20 years. The offer, if he pled guilty and gone to jail, was 5. He took 20 years to go into drug court because he's that committed in his mind that he can successfully complete it. If he doesn't, it's a mighty big hammer to drop down.
Well,
on
and
somebody. It's terrible to try to beat those addictions that these people have.
As a defense lawyer, when I'm helping my clients trying to make decisions about how to proceed with their case, when we're talking about drug court, if they're eligible, I have a very hard time with advising many of them, because I'm aware that you have to take a maximum sentence in order to get into drug court. It's an all or nothing proposition. And occasionally you have clients that you know are not going to make it in drug court. So, you know, I have to leave the decision up to them, but it's very, very difficult, and I won't advise a client that I don't think can make it to take that 20-year sentence, as opposed to maybe a 3-year offer, you know, that they could get, because the downside is so horrible on drug court. one of my little pet peeves, oh, you don't mind if I do a pet peeve, do you? Okay. And keeping in mind that I'm a defense lawyer here, if you have a drug addiction, and I certainly appreciate drug and alcohol addictions as being illnesses, but I find it sort of strange that if you're an addict, you have a possible route out of your situation. If you're a 19-year-old that's got a drug issue, you can apply for drug court. If you complete it, then you have no felony conviction. If, however, you're just a 19-year-old stupid guy, all right, that went out and knocked off some car radios because it was the thing to do, you are absolutely stuck with that felony forever. You cannot get it off your record. I find that bothersome that you have to be an addict. I'm almost tempted to say, you know, surely you have an addiction there somewhere. But there are people who do stupid things that aren't addicts. Is there any hope for them to get rid of a felony conviction?
There isn't, and the policy of the drug court is set by the desire to use very limited resources to treat those people who we in the drug court, the members of the drug court, think we can really help. And if you're not an addict, then you don't belong in drug court. And that's the driving reason why you don't get in drug court unless you're an addict, because that's what the drug court's set up to do. And what the problem we face as prosecutors is that there's a general feeling throughout the public, and it's certainly here in McCracken County, that the legal system is not fair, that it caters to those that have money. Speaking of money, that it caters to those that have money, there's two systems of justice. And I have, from time to time, people come into my office and they say, what do I need to do to make this felony go away? What do I need to do? As if somehow you can fix a case. And so those people, like you say, that sometimes go out and commit offenses in their first offense. Oftentimes people like you come in and you say, can we amend this down to a misdemeanor? And if you look at just the interest of the person who has committed the crime, at least from my point of view, you might agree to do that. The problem that we have is that you also have the feeling, certainly in this community, that the legal system is not fair. And so what we try to do, the easiest thing, at least from my office, would be say that, sure, you pay the money off, or you do certain steps, and we will change that to a misdemeanor, and then you'll be able to get that off of your record. But if we do that, the problem is what are we going to do for the next guy? Where are we going to draw the line? And we don't make the laws. My office doesn't make the laws. So the legislature has drawn the line, and what we think our responsibility is to enforce what the legislature's done. And so as we've got an adversary legal system, and that's one of the ways it plays out is that you got people who, if we simply looked at their interest, we would maybe have a disposition that's different than if we look at the entire picture and say, where are we going to draw the line? And if we say, well, this is a first-time offense for somebody, and they've committed a crime, and they're not eligible for drug court because we don't have it there, unless you're an addict, because that's what the drug court's set up for, and so they're going to end up pleading guilty. And at least with a drug offense, those can be now expunged after 2 years on a simple possession offense. But with regard to a theft or one of those other types of crime, if we're going to, the question that I certainly want my prosecutors to be asking is, if I'm going to do something special to take this off of this person's record, don't I have to do it for the next person that comes in, and where am I going to draw the line? So that's that's the decision making that goes in, is what's the best interest of the public, where are we going to draw the line. And generally speaking, we've made the decision we're going to draw the line where the legislature drew the line, and if they said it's a felony, as tough as it is, what we're going to do is we're going to say that it's a felony and it's going to stay a felony.
Well, you're talking about the legislature and the fact that we're all constrained by the laws that we operate under. And I have clients, that continually ask me the questions of how could they charge me? How can this be a crime? How can they prosecute me? How can the judge give, and my answer is, it's the law, and I can't fix that. It's just the law. One of the things that I believe the legislature has been a little fuzzy, one area of the law, is, or perhaps it was intentional, is the area of bonds. And when I looked through, I kind of scanned if you look on the jail site, it has everybody that's in jail, and it has their out date. And I actually counted of the 403 people in jail this morning, how many of them had an out date. And there were about 200 that had no out dates. And some of those are waiting for extradition and things of that nature, but certainly the majority of the individuals with no out date would be people who have not been convicted yet, who are in jail because they cannot make bond, because they're not just the poor, but certainly middle class people cannot make big bonds. Nobody has much extra money. What kind of determination? Well, first of all, Tim, when you return an indictment, or your office does, to the judge, I know the judge asks you to recommend a bond. Is that correct?
That's correct.
And when that indictment is returned, there are no defense lawyers in the courtroom that are representing the people that are indicted. And then you set the bond, and ultimately a judge decides what bond is going to be. How do you determine how to set a bond when you know you're dealing with people who have no money?
Well, back in misdemeanor court anyway, there's some guidelines for Class A misdemeanors and B misdemeanors and violations and things on bond. There are some guidelines there, and there aren't for felonies. That's true. More oftentimes than not, what will happen when the indictments are returned by the grand jury, the bond will already be set, and most of the time it's a bond that was previously set by the district court judge when the charge is taken, or by a circuit court judge in the occasional absence, which is very rare now, of a district judge to set those bonds. What I will do if they're in a direct indictment, I mean, the grand jury, the Commonwealth presents evidence to the grand jury. It may be a sealed indictment. Maybe they've been a big drug investigation and they're going to arrest 20 drug dealers, and so they'll come in with sealed indictments, and nobody knows what's in them but the judge and the grand jury and the Commonwealth's attorney and the law enforcement agencies that are going to go serve these warrants. So then we're straddled with having to set a bond. I think that circuit judges generally across the state, I mean, they're all different. I think that in McCracken County, I think that Judge Clymer and I are about on the same plane for what we think a certain crime is worth in terms of a bond that will bring a person back and that will protect the public in the event that you've got someone, a particularly heinous crime, a murder, or something like that. Those are the kind of cases where we look at it and say we're not going to allow a bond. I mean, you can't get out because, and it's kind of the videotape rule. I mean, if they got 100 witnesses that see somebody walk in and shoot you, then I think the likelihood of conviction is pretty good, and the likelihood that you're the person that did it with 100 witnesses watching you and it's on videotape, then probably you're dangerous, is what my thought is. And that's part of the consideration we have to give, is protection of the public, and we have to consider the defendant's circumstances as well. And I'll tell you, I mean, the more crimes that are committed by an individual, the likelihood is their bond's going to be higher. I mean, if they've got a very long record of criminal activity and conduct, then the likelihood they'll commit other crimes while they're out on that bond is high, and so we'll make the bond high. And I have them that have been able to make the high bonds. Got one today that made a high bond, got out, got caught again selling drugs, and now he's being held in no bond because he's a habitual criminal, and those people are going to commit crimes. I mean, we can't follow them every day where they go. But
I get frustrated. I've got a case, a current case where I have a co-defendant, a defendant who is similarly situated to another defendant. One defendant has a rich uncle, apparently, who has posted a very large cash bond for him. I mean, they're charged with the same thing. The facts are the same for both of them. My client does not have a rich uncle, so he is not out of jail because he can't make his bond. Now, while I appreciated that, being rich is always better than being poor, and you get better, dental work and stuff if you're rich than when you're poor. But is that ever a consideration for you when you're setting bonds, the person's ability to make that bond as opposed to just the crime itself?
Well, we're supposed to consider the ability to make it, but frankly, I mean, you've represented clients. If we set a $5 bond, they couldn't make it.
That's true.
And that's part of the problem with the bond system. They thought they did a great thing.
Yeah.
Governor Carroll thought he did a great thing when he did away with bail bondsmen, and maybe he did. I was a young man then back in those days. I remember Jimmy Johnson's bail bond store down on the 4th Street. But I mean, that gave the indigents a chance to get out of jail. And now, you're right. I mean, if they don't have the rich uncle or somebody owns property or they can go amongst family and friends and collect up some cash, they can't get out. Whereas under the old system, and maybe it was as corrupt as the Carroll administration wanted to make it sound. I don't know, but I know a lot of states still have bail bondsmen, and the theory behind the bail bondsman was that if they're going to come back, I mean, most people have seen that big guy on TV that goes and chases down these people, and bounty hunter guy, and hauls them back over to the courthouse, and frankly, what we got is a whole nother level of bureaucracy in state government that deals with these people on bond. And now we do have a new system, as you are aware, that pretrial services now, we can place these people as almost like they're on probation. If we give them a break on the bond, a 10% or something, they can report to pretrial, they can have a job, stay out of trouble, random drug tests and that type of thing, and that's in place. So it's better.
And the federal system kind of works like that.
Well, it's better. It's better today than it was even a year ago in terms of your indigent clients. But at the same time, who's to say, well, okay, because he's got a rich uncle, he can post $5,000 cash, that we should make this guy's bond, 10%. Because he can't get the $5,000 cash. I mean, they did the same crime, the bond's probably going to be the same.
Yeah. Unless
one of them's got a really bad record and the other one just happened to fall in. I'm going to touch back on one thing that you and Mr. Kaltenbach talked about, and that's the idea of getting rid of these felonies. I mean, the legislature really, frankly, I think, should act in this regard because he's right. I mean, if you do a drug felony, there's a provision in law that allows you, if you behave yourself and don't get any more trouble, and then after a period of time, you can get that expunged from your record. What most people don't know is what you can't get expunged from your record is a charge that was brought against you. If you were charged with a crime, tried by a jury and acquitted, that stays in the court record forever. You can't get rid of it. That's not fair. If you're charged with a crime and later the Commonwealth finds out you didn't do it and they dismiss it, you can't get that off your record either. I've talked to the legislators about this, several of them, and their answer to me is always the same thing. Well, our theory on that is that it's like, the bad teacher who's a child abuser, or, the Catholic priest problem, and all these things, is that if there's enough smoke, there's bound to be fire. So we're going to leave those charges on there. I said, well, why don't you just limit that to sexual offenses? Why, if I was charged with shoplifting, and obviously didn't do it, and the charges were dismissed, why should that be on a record that somebody can go look up and say, well, old Hines here, he got charged with shoplifting. Wonder what that was all about. Shows is dismissed. They need to address that, because that's not fair to the average citizen, the wrongfully accused. It's not fair, it's not right, and it needs to be changed. And another area, I think, too, I mean, all human beings mature at a different time, different ages. One crime I just can't get a handle on. I just don't understand it. I just cannot stand to see it coming through, is first-degree criminal mischief. Just going out and shooting up some stranger's car, or smashing car windows, or paintball. I don't understand it. I don't get the thrill and destruction of other people's property that hadn't done anything to you. I understand the mad girlfriend or boyfriend that goes and slashes the tires, but I don't understand some random act of kindness from a 19-year-old boy who wants to bash out my windshield. Don't understand it. But that's the kind of stupid crimes that young men and women will commit. And that's the kind of stupid crime that can follow them for the rest of their life, through their business life. They can go to college, doesn't matter. There's that blank on that form. And I've had many a parent call me, friends of mine, and have said, what do they do? And I said, we've got to be honest, because they're going to find out. And if you're dishonest, then and they don't get a job. I mean, they don't get a job. Recently, some athlete around the area did something really stupid, and it was a prank gone bad, is what the paper said. But the charge is a felony.
Yeah.
Now, whether it's resolved that way or not, I don't know. Frankly, I think it'll be resolved as some type of misdemeanor, or maybe a pretrial diversion even. But even so, it's there. It's on the record. It's there. And there ought to be an avenue for good kids that did one stupid thing in their life to get that erased from the record. I agree that should be the law, but it's not.
I don't see what would be wrong with having a 10-year threshold on felonies, to like your driving records. After 5 years it comes off, and if you've got like a D or a C felony after 10 years, it goes away. But they just won't let me make laws. I mean, they won't put me in charge.
Obviously, Mr. Kaltenbach, she's going to have to run for state senate or the House.
Yeah.
One thing too is I'm used to watching these programs, and that's never said. We've got a prosecutor here. As a result of people being in jail, as a result of our jail being full, as a result of so many people in prison, one thing we have had is we've got a crime rate that is much below the crime rate that we did 30 years ago.
I'm going to have to stop you. We are out of time. We want to thank you for joining us. If you'd like to see this again or see any of the other Law Week activities, you may find us at paducah2.org. Thank you for joining us.